All right, sorry about that, online audience. But just to kind of give a quick recap, we're going to hear first for some community partners, and then we'll get to our main presentation. So I'm just talking a little bit about the library services that we have pertaining to legal information. So on this page, one of our research pages for law and legal resource, you can find information about the Justice Center, the Eviction Diversion program that we're going to learn about here in a minute, Colorado Legal Services. And then if you want to look at the Colorado revised statutes, those are available there, as well as the free clinic that the library runs. So those are just a few of the things that we have to offer. I do want to talk for a minute about this eviction diversion mediation program. Brett couldn't be here with us tonight. And so this is a free, it's a free mediation program between tenants and landlords. It's offered through the Office of Dispute Resolution. And so it covers a variety of things. And so you can take a look at this flyer to learn more. I'll put the link for the flyer in the chat when I get done here in a second. So you can learn more to see if this would work for you and your landlord or you and your tenant. So next I'm going to hand it over to Laura.
Thank you, Deb. I am Laura McKernan. I'm with the Justice Center. I'm the executive director there. We have a few programs that you could use. Our first one, our oldest one, is called Find a Lawyer. You will find it where it says need a lawyer. And if you click on need a lawyer, sorry.
Here, this doesn't work very well.
There we go. So if you hover over need a lawyer, it'll say find a lawyer. That's our oldest program that we have. And that one is to pair you with an attorney in case you can't afford an attorney. We do have landlord tenant attorneys that are part of our volunteers that will help you with your case. You have to go through a process, you have to be verified, but other than that, you can definitely use that resource for yourself or somebody you know. We also have clinics that you can attend. Call a Lawyer is over the phone every single Wednesday, so it's happening right now as we speak. The second one we have is Ask a Lawyer, and in that one, it's our newest clinic. And what you do is you go into our website, you click on Ask a Lawyer, and you will see that you need to fill out some information. And usually we like to say that it takes us about 7 business days to get back to you, and that's just in case that one of our attorneys is out on vacation and we need to recirculate it, or they're on trial and we need to recirculate your question. So usually it takes us 7 business days or less to get an answer to you on your landlord tenant questions. These are anonymous, so you don't have to tell us who you are, and the attorney will not tell you who he or she is either. So it's nice to have that resource. In our website, you can also find educational tools. There's one that's very important for landlord tenant issues, which is a toolkit that has been developed for you. It is in English and in Spanish. It's also in Korean. So if we do have members of our community that are English, Spanish, or Korean, you can go in there and you can find that resource. So you'll see our toolkit, eviction prevention toolkit. And that's for you to read at your own leisure. Please do so. It's a really good resource for you so you understand. We also have forms that you can use. Some of these forms are for basic questions that we've been fielding in our clinics that we just hear them repeatedly. And so we had attorneys come in and say, this is what a form of that nature would look like. One is a mutual rescission of a lease. So when you want to get out of your lease. And another one is warrant of habitability demand letter. So those are 2 very important questions that we hear over and over. How do I do this? So this is how you do this. We also have videos on YouTube, which are linked here. And you can go to those videos and you can watch them at your own pace. Pause, write down your question if you have to, send it in to Ask a Lawyer so we understand what you're talking about. So you can go to those. It talks about service animals. That's one of the big questions that we receive as well, especially in this town. They don't run a recognized animal. What is this? Is it a service? Is it a therapy? Is it? So all these questions that you might have, there's a video on that. There's a few that have to do with COVID. I know a lot of us are receiving a lot of questions about those regulations. There's one that I always like to say you should watch, which is Crucial Conversations with Your Landlord. We are so excited to sign a lease and then there's a lot of problems. So let's watch that video before we even start. And once we're in there, there's also different questions we could have. So please feel free to go to our website, the Justice Center. That's the name of our organization. And our website is justicecentercos.org. It's also in Spanish, the website. So if you speak Spanish as your first language, you can click the button that says Español and it will get you there. Thank you for having me.
All right, Katrina. Okay, whatever's easiest. So let me know where to click.
My name is Katrina Brown, and I am with Colorado Housing Connects and Brothers Redevelopment. I'm a housing counselor. And at Brothers Redevelopment, we run a line called Colorado Housing Connects, as you see on the screen, where we field questions from renters' rights questions, tenant landlords questions, warranty of habitability questions. We handle a lot of home buyer questions. Can you click on renters down there, please? Thank you. And scroll. And keep going. So we do a lot. We do a lot of helping renters find affordable housing. We do a lot of helping renters find money for rental assistance, deposit assistance. We've been fielding people to ERAP, Emergency Rental Assistance Program, since COVID began. If you all don't know, yesterday was the last day for the ERAP program, and DOLA has closed it. However, Colorado Springs has an ERAP program through Catholic Charities, so they are covering Colorado Springs and El Paso County if anyone is in need of rent assistance. It's not as broad as the ERAP program with the state, so they're not giving out as much money. But if you're still in need or know someone that is in need of rent assistance, there is an ERAP program, and you can call our 1-844 number. We also, you can go to homeowners.
No, you're fine.
Thank you so much. We also help homeowners who have been hit hard with COVID or hit hard with job loss. We help them stay in their homes. We answered a myriad of questions about foreclosure and help them navigate with their loan officer. We also help first-time homebuyers become first-time homebuyers. We work under CHAFA, and we teach a first-time homebuyers class here in the Springs and Denver. And in the Denver area, scroll back. I think it's going to just keep taking us back to the same place. And we also have, I think it's at the top, or maybe we're missing it. We also have a home modification and repair program where we will go out to homes that people are aging in place, or they need grab bars, or they need new tubs or ramps, roofs, things like that on their house. And we work under a grant. We're a nonprofit, and we will help with things like that. We have a guy, Jonathan, he's amazing. He'll go in your house and you think you're just getting a grab bar. And he's like, no, this is unsafe. You need new stairs, you need this, you need that. And he's magic. Get all of those things done for you. But the biggest thing that we do is run the Colorado Housing Connects hotline. So if there's any questions that anybody has, they need to navigate their lease, they have tenant landlord questions, warranty of habitability questions, we have navigators that answer those calls and will help you through. So thank you for having me.
Thanks, Katrina.
Let me just get this last.
Okay, so now we're gonna switch to the main event. So Clinton Albert is a housing attorney with Colorado Legal Services, where he has served for 4 years. His caseload is made up solely of landlord-tenant matters and covers a broad range of legal issues within that area. Clinton will talk about a wide variety of topics such as lease basics, reasonable accommodations and modifications, deposits, repairs, evictions, and updates on recent Colorado legislation and housing acts. So please welcome me and join me, and please join me in welcoming, Clinton Albert.
Situated, folks. Can the folks online hear me okay? If you can't, please holler out. For folks in person, can everybody see the screen okay?
Yes.
All right. First of all, I want to thank you all for taking the time to come out this evening. My name is Clinton Albert. I'm an attorney with Colorado Legal Services. I'm going to do my best not to stand directly in front of the projector throughout this. Colorado Legal Services, for the next few days, we're going to be located at 617 South Nevada Avenue. I have to look back up because the new address, I'm still not used to seeing that. We are moving locations over the course of the next week. We will be located at 102 South Tejon Street in Suite 430. That's going to be right at the intersection of Colorado and Tejon. So a few things to keep in mind as we go through this evening. One, this presentation is for informational purposes only. Housing issues require a thoughtful analysis of both the facts and the law that would apply to a case. COVID protections at this point are all but expired. There are some exceptions there. If you are in a property subject that is subject to CARES Act, you are still entitled to a 30-day notice because that provision of the CARES Act never expired. So that remains the law for any property supported, any CARES Act properties. But if you are facing a housing issue, Colorado Legal Services does offer assistance to folks for no charge if you are a low-income member of the community or a senior citizen. So you're more than welcome to apply for services. You can apply. You can apply in person at 617 South Nevada for the next couple of days, or 102 South Tejon. You can apply online at coloradolegalservices.org or over the phone at extension 444. But a couple things to keep in mind. The way this presentation is kind of set up is to think about your tenancy from beginning to end and what may kind of come along throughout that time period. First of all, I think it just kind of up front, there is Colorado does have a prohibition against discrimination based on the source of income. This is the state version of our Fair Housing Act. So landlords are not able to discriminate against a tenant or an applicant based on that person's source of income. Source of income, that's the legal definition for it. And folks, just so you know, the slides will be made available. So long as you have registered and have your email address back there, they will be emailed out following the presentation. So really what this boils down to is if you are an individual that receives some kind of housing choice voucher or something to that effect, that cannot be a basis to deny your tenancy or an application for tenancy. And then there's a link to that. As I indicated, we will make the slides available to everybody. One of the main things whether you're a landlord watching this or you're a tenant, is to put everything in writing. If you have a verbal agreement and a written lease, there's a strong chance that your lease says that any modifications or agreements must be in writing and signed by both parties. So if that's in your lease agreement, one of the main things you need to keep in mind is any verbal promises that you make or any verbal agreements, they're not going to be okay. They're not going to be binding. So you want to make sure that you put as much as possible into writing. It also creates a record in case there are any disputes throughout the tenancy that hopefully would resolve those disputes or avoid them altogether. Oral lease, a lease is a contract between you and your landlord. Regardless of how you may have known each other prior to the landlord-tenant relationship, family, friends, somebody from church or a coworker, it's a business relationship. So the personal matters, you need to try your best to set it aside, because at the end of the day, this is a contract matter. Oral leases are valid. You can have an oral lease. Generally not the best for either person, because it's hard if there's any dispute over any term of the tenancy, it's going to be hard to prove that. They are valid. They're going to be presumed to be month to month. So if you find yourself in a situation where, well, I was told I could live here for as long as I wanted to, that's not going to be enforceable because it's not put in writing. So with an oral lease, it's valid. It's going to be presumed to be month to month, unless there's other factors. This is why I can't give legal advice throughout this presentation, just because the opinion may change based on the facts of the case. So this is all, keep in mind, this is all before we move into a new residence. So one of the first steps is going to be applying for the new residence, and what the rules that are applicable to the application process can be found in the Rental Application Fairness Act. This lays out what a landlord can and cannot charge for rental applications. So first of all, cannot charge an application fee unless that entire amount is used to process the application itself. This is not, application fees are not designed to be an additional source of revenue for potential landlords. That cost can be either the actual cost to process an application, or if we think about an apartment complex, it's maybe sending off a dozen or so, the average cost to process those applications itself. Can't charge different amounts for fee to different applicants. And as a landlord or as a tenant, you're entitled to a disclosure on this is what I believe to be the costs. If you're applying, make sure that you put down a good mailing address, not necessarily where you're currently living, but a place that's dependable that you can receive mail. Because if there's any amount that is remaining from that application fee, that prospective landlord does have to make good faith efforts to return those funds to you. So if it's kind of the average cost and there is some kind of remainder amount from the fee paid, make sure that you have that good address. That way you can receive those funds. Landlords have to make a good faith effort to return those to you, but they don't have to go out and hire a process server or an investigator to figure out how to mail it back to you. So what can be considered on an application itself? For credit history, credit and rental history, only the past 7 years. So if you have an eviction that's 8 years old, that can't be used as a reason against you. If you've got a bankruptcy 8 years old, same issue. However, anything within that 7-year period can be used as a reason to deny an application. What about criminal history? So a couple of things to break down here. It's arrests versus convictions. In arrests, never. To be arrested 100 times. If you have 0 convictions, then the 100 arrests are not a basis to deny your application. With convictions, if it is a conviction that is within the last 5 years, that can be used as a basis to deny an application. If the criminal conviction is outside of 5 years, there are only certain convictions that would be a basis for a landlord to deny your application. Those are going to be, generally speaking, offenses related to methamphetamines, not simple possession, but manufacture, or possession of precursor, possession with intent to distribute, distribution. Those are problematic. Any offense that requires a person to register as a sex offender pursuant to Colorado revised statute, any homicide-related convictions, and stalking. Those are all basic criminal convictions where regardless of how old that conviction may be, that can be used as a basis to deny an application. So you put in your application, how are you supposed to figure out if it's denied or not? Well, the landlord has to provide a written denial. They have to put in writing that the application has been denied. They also have to put in writing why the application has been denied and provide that written response within 20 calendar days. So that's, again, goes to the importance of providing that good mailing address, because if that's lacking, then the letter is going to be sent out to general delivery and chances are it's never going to be received. So if the landlord doesn't follow the law, they include let's say they say that you have a theft conviction from 12 years ago, and that's the reason to deny the application. Well, as an applicant, you have the right to send a demand letter saying, hey, you denied my application for the wrong reasons. I'm giving you 7 days to fix this. And if that doesn't happen, then as an applicant, you can take that landlord to court and try to seek 3 times the amount of the application fee, the court costs for filing the lawsuit, and reasonable attorney fees if you hire an attorney to represent you in that matter. You've got to give the landlord at least 7 days to fix the problem. All right, so you point out the error, send the letter. I'd recommend sending it with some kind of tracking on it to show that it was received. And if that's not fixed within 7 days, then you have the ability to file that lawsuit. So landlords have the ability to fix that violation. If the reason stated is invalid, then hopefully you'll get a letter stating, well, all right, we've now approved your application. If the basis for the denial is that, let's say there's a manslaughter conviction from 10 years ago and bring the lawsuit, then the landlord is able to recover attorney fees and court costs for the meritless lawsuit because it was denied based on proper grounds. Down below at the bottom there, you can see the statutes that relate to the Rental Application Fairness Act. So we're now at the stage where the application's been approved and you're sitting down to sign the lease agreement. Bring the magnifying glass, read the lease. I don't care how many pages it is. I don't care if it's 1 page. I don't care if it's 100 pages. Your signature's on it. And it is not a valid defense to come into court and say, it was really long, I was in a rush, I just kind of skimmed it. If you're putting your name on it, you're signing it and you're saying, I've read everything, I agree to it all. So don't do that unless you have read everything. And if you have a question about one of the terms, you can ask the person, you can ask the property management company, you can ask the landlord, you can also call the Ask a Lawyer clinic on a Wednesday. Because there are going to be some lease clauses where if you agree to it, you may be waiving some of your rights as a tenant. There are going to be some lease clauses that even if you do agree to it, it's not going to be enforceable in court. And we'll talk about some of those, but you really want to review your lease. This is what you're agreeing to. This is what you're taking on as an obligation as a tenant. What's the length of it? Were you told verbally that it's month to month, but then you're signing a 12-month or vice versa? How long are you actually securing this residence for? What happens at the end of the lease term? Does it automatically renew? How much notice do you have to give to your landlord if you don't want to renew? What if your landlord doesn't want to renew? How much notice do they have to give you? What about any potential fees? For example, and we'll touch on this in a little bit, but late fees. If there are any late fees, it must be disclosed in the written lease agreement, which then brings it back to, well, what about an oral lease agreement? Well, if you have an oral lease agreement, you can't be charged late fees because there's no written lease agreement. So these are all very important things to keep in mind. What about responsibilities for upkeep and maintenance? Do you have an obligation to maintain the yard, sprinkler systems, snow removal, any kind of common areas? What do you have to do to make sure that you're meeting your duties and your obligations as the tenant to make sure that you're staying in compliance with the lease? Other things to pay attention to, notice related section. So there is a type of tenancy called an exempt residential tenant agreement. Sorry, an exempt residential agreement. It changes the amount of notice that you receive. If you are going to be if you are agreeing to an exempt residential agreement, that's going to be in the lease. That has to be in the lease. So you want to make sure that you read through it to make sure that how much notice am I going to get? Because if it's exempt, you get 5 days. If it's not, you get 10. Warranty of habitability sections. Your lease is required to have the electronic address for a warranty of habitability notice. This is important because if you find yourself dealing with a conditions issue and you send a notice to the wrong email address, where it's supposed to go to a portal and you just submit a work order, you're not actually sending a warranty of habitability demand. So that becomes important then if you make the decision to withhold your rent, because then you're withholding your rent without the legal basis to do so and placing yourself at risk of eviction. So what's an exempt residential agreement? It's a lease for a single family home. If you're renting an apartment, you can tune out for the next few seconds. It's a single family home that is leased by a landlord who owns 5 or fewer single family rental homes. And it's a notice is provided in the lease agreement itself that this is an exempt residential agreement. That really means that the 10-day notice period to cure a lease violation or non-payment is then 5 days instead of 10. Oral leases cannot be exempt residential agreements because, well, if it has to be in writing in the lease agreement and it's an oral lease, there is no writing, there is no exempt residential agreement. What are some of, I mentioned as we're reviewing this, what are some things to be on the lookout for that just wouldn't be enforceable? As a tenant, you cannot waive your right to the return of the security deposit. You cannot waive your right to the warranty of habitability. There is an exception that we'll touch on, but generally speaking, you cannot waive that in the lease agreement itself. You cannot waive your covenant of quiet enjoyment, which is this implied agreement that you have the right to enjoy your residence as a resident. You're not going to be setting up beside, let's say a print press. I say print press because I've read a case from the early 1900s on the covenant of quiet enjoyment. It involved a printing press being put over top of an apartment, a hole being in a roof, and they were living essentially in a printing press. So that was not a residence. You cannot waive your right to a demand for unpaid rent. You can be late on your rent every single month. Would advise against that, generally speaking, but you still have the right to be able to cure that non-payment or that late payment each and every month, and you cannot waive your right to a demand for payment or possession. You also cannot waive your right to a court process for a forcible entry and detainer case, an eviction case. Evictions happen in court. A judge decides whether or not a tenant is evicted. You cannot waive that basic right. You also cannot waive another unenforceable lease provision is late fees. So any late fee, the maximum amount that you can be charged for a late fee is either $50 or 5% of the unpaid rent, whichever amount is greater. That's it. You cannot agree to unenforceable late fees if you do have a lease that has the late fees are beyond what is permitted by the law. That will not be enforced by a court. You also cannot be subject to an unreasonable liquidated damages clause, which assigns a cost, which let's say it just says, if we have to file an eviction, you're going to be responsible for the remainder of the rent. That's not going to be an enforceable lease clause. Also, if there's any kind of provision about attorney fees, that attorney fee clause must be reciprocal. So it must be that both the tenant or the landlord have the right to pursue attorney fees if they prevail in an action. If it's not if both sides don't have that option, it's not going to be enforceable. So we've reviewed the lease. We don't have any questions. We're comfortable with the terms of it. We're signing it and we're starting our tenancy. Get a copy of that lease. Not only is it just a good practice as a tenant to have that copy, in addition, keep everything kind of in the same location. Starting with the application, any receipts that you receive for payment, anything in writing that you receive, keep it all handy in one kind of folder or scan all the documents and keep them backed up somewhere. That way you have an easy access to these records. If there's ever a dispute, or if you ever find yourself talking to me, the first thing I'm going to ask you for is give me all your documents. So make sure that you're doing that work up front throughout your tenancy to keep all the documents. Because if you got something 6 months ago and there's a dispute about it, today, well, you want to go back and have those records from when this, what was said 6 months ago, what was written 6 months ago. In addition, you also have a right to it. You also have a right to a copy of your lease. Make sure you request it, but the law requires your new landlord to provide you with a copy of your lease within 7 days of you signing it. I kind of hinted at this just a few seconds ago, but also keep copies of your receipts for rent and security and any kind of security deposit that you paid. You have a right to those. If you have a right to the receipts, if you paid by cash or money order. If you paid by check, then there's going to be an electronic record created with your bank statements as the checks have been cashed. But if you pay by cash, if you pay by money order, you have a right to a receipt. If you pay in person, you have a right to that receipt immediately. You pay your rent, you get the receipt in exchange. If you mail in your rent, you have to request a receipt, and your landlord is supposed to mail that to you within 7 days. I would also recommend that if you're paying on some kind of app, to print off the screen every time you make a payment, showing that confirmation of the payment to create your own records. What about rent increases? Let's say we're on a month-to-month lease, or our original lease term has expired and it's rolled over to a month-to-month, or we're just on an oral tenancy. Landlords are not allowed to increase the rent more than once in any 12 months of continued occupancy. It doesn't matter if there's a written lease. It doesn't matter how long somebody's been living there, except for that 12-month part. Whether that's 12 months or 112 months, the rent can only be raised once in 12 months. And it doesn't matter if it's a 12-month lease, month-to-month lease, indefinite term, only raise the rent once within the 12-month period. They can also only raise the rent upon 60 days written notice, provided to you as the tenant. So if your landlord tries to raise the rent or gives you a notice to quit, saying you have to move out at the end of the month or pay the new rent, that's going to be an invalid rent increase, because landlords are not able to provide a notice to quit to try to circumnavigate or get around that 60-day requirement. Late fees. This is a pretty significant change. This has been in effect for about a year now, so October of 2021. So if you have an older lease, say you signed one in 2020 or anytime prior to October 1st of 2021, very much recommend that you take a look at your lease to see if you're still subject to late fees, because you may not be anymore. So landlords are not able to do any of the following things. Cannot charge a late fee unless the rent payment is at least 7 calendar days late. So if your rent's due on the 1st, you are not subject to a late payment until late fee until the 8th. The $50 or 5% amount that we've touched on a little bit before, that's the maximum amount that you can pay. If your rent's $1,000 a month, that means the most you could pay in a rate and a late fee is $50. So if your rent's greater than $1,000 a month, make sure that you're paying attention to what you're being charged as a late fee if you see it on any kind of invoice, because if it's greater than 5%, you're going to have a cause of that. You're going to have a claim against your landlord. It has to be in the lease agreement. So this can't come up after the fact. You can't evict somebody for failing to pay late fees. You just can't. It has to be rent. You can't end a tenancy because somebody's not paying their late fees. You can't impose a late fee just because if a housing subsidy is late. So if you're a landlord and you've entered into a HAP contract with a voucher provider or local housing authority, and their portion of the payment is late, that does not give you as a landlord the right to charge the tenant a late fee. Also can't charge late fees more than once unless that amount remains less than $50 or less than 5%. So if there's a provision that says we're going to charge $50 a late fee a day, it's not going to be enforceable. there's a provision that says $5 a day up to 5%, that can be enforceable. It just depends on the facts of your case and the way your lease is written. Also can't pay interest on late fees. Continuing. So landlords are also not able to charge late fees unless they provide the tenant not only with that notice in the lease, but an additional notice within 180 days saying you're being charged a late fee for the late pay for your rent being late. Any provision that doesn't comply with this is void and unenforceable. If your landlord violates this, or landlords, if you're violating this, you don't have an opportunity to cure necessarily. For every violation of the late fee statute, there's a $50 penalty. There's no opportunity to cure. So make sure that your leases are written correctly and make sure that your accounting department's gotten these updates. If that's the $50 statutory penalty. As a tenant, if you send your landlord a demand letter stating you have 7 days to cure these invalid late fees, and your landlord does not, then that penalty, the floor of it's going to be $50. But a court could award up to $8,000 for each violation of the late fee statute. So this can become a very expensive proposition for a landlord. So if you're facing late fees as a tenant and something doesn't seem right, or you're concerned about the amount being charged, strongly encourage that you seek some legal advice on that matter. Landlords, if you have any concern that your late fees may be unenforceable, same thing, I would highly encourage you to seek legal advice to make sure that you're not setting yourself up for the financial ramifications of an invalid and illegal late fee. If you bring the action for invalid late fees, you can also seek attorney fees as well. It is a defense against an eviction that it is an invalid late fee, and that is the basis for the eviction itself. And this is key as well. A late fee is distinct from rent, and a rental agreement cannot classify a late fee as rent. That is significant because when you pay your rent cannot be applied to the late fees. So, and folks, I haven't been checking the chat. I will check that towards the end of the presentation once we get into the question portion of this evening. But moving on from late fees, we've gone through the lease agreement. We're about to move in. The truck's outside. Before you bring the first box off the truck or out of your car, go through with, maybe you've gotten a walkthrough checklist from your new landlord. If you have, go through and fill that out. If you haven't, still, before you put one piece of your property in your new place, go through and take pictures. Document the condition of your residence. Document everything. Open the cabinets, make sure there's any kind of dings, any kind of scratches. Just make sure that you're testing all of the faucets to make sure you have appropriate water pressure, that you run the dishwasher to make sure it's functioning, that your oven turns on, that you take pictures of the oven to make sure it's clean, lift up your stovetop to make, if you have gas burners, make sure it's clean under there. Because at the end of your tenancy, you're going to want to have a record of how you receive the property. Because if there's any kind of security deposit deduction for the condition of it, you want to be able to show, hey, this is what it looked like when I moved in. There is no damage here because this is what the residence looked like when I first moved in. I would also recommend that after you take those photographs, again, back them up, put them on a flash drive, put them in the cloud. Also, provide your landlord with a copy of them as well, along with any kind of walkthrough checklist. And if you've got a list of issues and you didn't receive the checklist, jot them down and provide it to them. You're being a thorough tenant, and you're also alerting your landlord, hey, there are some issues here. And that's a good thing for both parties, because if addressed early enough, those issues don't spiral out of control, and it becomes a more cost-effective way for the landlord to be able to make the repairs before they get too large. And again, think back, this is a business relationship. You're not being a bother. You are paying to live here. And you have the right to make sure that what you're paying for is what you agree to. So submitting the maintenance request is not unprofessional. I would say that is being a responsible tenant or making sure that you're not letting issues kind of spiral out of control in the residence. So why are pictures important? Again, it documents the condition of the residence at the beginning of your tenancy. Everything, take pictures of it, whether it's damaged or if it's undamaged. That way you can show that, hey, this hole did exist, or this ding was there, this dent was there, this discoloration was present. And this, again, this is going to be really good evidence, or potentially good evidence if you have to take, if you're disputing a security deposit deduction. If it's possible, try to do a walkthrough. I think this is good to take this extra step. You can identify pre-existing damage together, and that way both you and your landlord enter into this new residence with the same understanding of the condition. And you can also make kind of talk out how some issues are going to be repaired in a timeline form. Be critical, don't be unreasonable. Again, not being a bother by pointing out that you don't have good water pressure in your shower, because that may be indicative of a larger issue that no one's aware of yet. Business relationship, treat it like such. Your landlord's not doing you any favors, and you're not doing your landlord any favors. But you're being a responsible tenant and you're doing your best to maintain the property to the best of your ability. So what about the rules and regulations of a lease? These are going to be additional conditions of your tenancy. If you find yourself living in a mobile home park, there's going to be rules and regulations. Make sure that you get a copy of them. But you may see a reference in your lease that your tenancy is subject to the community rules. Well, make sure you have a copy of those community rules, because you're going to be expected to follow them. And if you don't have a copy of them, you could unknowingly violate a rule and put yourself at risk of an eviction. So make sure you be on the lookout for that through the lease as well. You may receive a copy. If you don't, but you think that there might be some, ask. All right, so this is one of the bigger sections that I tend to get a lot of questions of, which is regarding the warranty of habitability. This is the promise that your residence is fit to live in as a human. Just to kind of boil it down to what are we talking about here? There's a list of things that by law must either be present or not be present. The packet that's referred to can be found online, but we will review those conditions here shortly. Electronic notice. This is what was touched on when we were discussing the reviewing your lease. Electronic notice, it's important to know what that is. It is not a work order. A work order is not electronic notice, because a work order is saying you have an issue. It is not saying that your residence is uninhabitable by law. So there is a difference between the two. Make sure you can certainly submit both, but to err on the side of caution, I would strongly recommend that you submit a warranty of habitability notice in addition to any work order. So what makes up an electronic notice? By email or some electronic portal system or messaging system that's available to both your landlord and you as a tenant, and it's specified in your lease agreement. If your lease doesn't have that section, then prior practice will control. And what I mean by that is, if your lease doesn't say this is where you can electronically send a notice for issues regarding the warranty of habitability, but you've received an email from the property management office about maybe some seasonal maintenance that's going to occur, or you've received a text message, you can then respond in that fashion. So if your lease is silent, but your landlord, you and your landlord have texted previously, you can send a notice via text message, right? But if your lease does say you have to email it, then sending it by text message is not going to be valid. So make sure that you know what your lease says, because you have to follow what your lease says, even if you've been practicing a different way of communication. So again, if your lease isn't specific, you communicate with your landlord in a manner that the landlord has previously used to communicate with you. So that's important, because if you've been sending text messages but you never get a response, that's not a valid way of communication, because that's not how your landlord's communicated with you previously. Also, again, keep copies of everything. It's very difficult to prove that a document says something if you don't have the document. So when we're talking about the warranty of habitability, what do we mean? Well, it means that you've got waterproofing, proper windows, doors, your plumbing and gas is in good working order. You've got running water, reasonable amounts of hot water, proper fixtures and connections to sewage disposal systems, functioning heating facilities in good working order and in compliance with the law. Electrical lighting and wiring, in good working order and in compliance with the law. Common areas under control, the landlord kept reasonably clean. In order for a common area to rise to the level to make your residence uninhabitable, it essentially has to be in such a bad shape that you're no longer able to use your home as a home. I don't know what that looks like, to be very candid with you, but if it's dirty, it's probably not going to get to that level of warranty of habitability. Appropriate response, extermination in response to infestations. And we've got our little friend, the bed bug there. There are additional rules for bed bugs. So as a tenant, if you think that you have bed bugs, you have to let your landlord know immediately. And that becomes important down the line. So if you think that's the case, you have to let them know immediately. After your landlord receives that notice, they then have to take prompt action. And within 96 hours of receiving your notice, they have to provide you as the tenant with 48 hours notice that they're going to enter in their intent to enter your residence, do an inspection, and they have to get an inspection by a qualified inspector. That doesn't mean they just go down the hallway and have somebody go look around your house. They have to call somebody in to do an inspection. And landlords are able to enter contiguous units. So if your neighbor sends a notice, your landlord then can also inspect your apartment as well. If an inspection confirms the presence of bed bugs, then your landlord has to inspect all the contiguous units, all of the units that are touching yours. And landlords are the ones that are responsible for all the costs associated with an inspection for and the treatment for bed bugs. You're going to be responsible for the cost of preparing your residence, but they're going to be responsible for the cost of the actual inspection treatment. And by the cost of repairing the residence, if you've got to, oftentimes the inspection companies are going to send you a checklist. Get your furniture off of the, 2 feet off the walls, put all your dishes in an airtight tub. You're going to have to make sure that you're responsible for that and that you get your apartment ready, because if your actions delay the inspection, then some of those costs could then become your costs and not your landlord's. All right, so after the inspection is completed, landlords have to tell you as a tenant within 2 business days whether or not your residence contains bed bugs. If it comes up negative, then that notice also has to tell you that you can go get a second opinion if you'd like. If the inspection comes back that confirms the presence of bed bugs, the inspector has to provide the landlord with a report within 24 hours. It's going to be tricky for you as a tenant to know if that happens, but landlords, if the inspector's kind of messing around with you, you have a right to that report within 24 hours from there. So within 5 business days of the inspection, landlords have to start treatment for bed bugs. And that could include retaining pest control. It's my opinion that it's not sufficient just to hand you, if you're a tenant, it's not sufficient for the landlord just to hand you a can of Raid and say, go nuts. I do not believe that meets the requirements or their duties under the warranty of habitability. So again, as a tenant, you have to do what you need to do. You have to do your part in getting your place ready. All costs associated with preparing the residence for treatment. So if you've got to turn your furniture over and rip the upholstery off the bottom, you've got to do that. You've got to make sure that you're putting your place in a position for it to be inspected. If you knowingly and unreasonably fail to comply, then you're going to be liable for the cost of the treatments on not only your place, but any contiguous units as well. So make sure that you're doing your part here. And that's also why it's so important that if you believe or you suspect or you know that you have bed bugs, to say something immediately. Don't give the infestation a chance to spread. landlords, if you know or you reasonably suspect that you have a unit that contains bed bugs, you cannot rent it. And if you're applying for places and you can ask, when's the last time that this has been inspected for and found to be free of bed bugs? So landlords are obligated to say if they know that the unit, if the unit within the last 8 months contained bed bugs, or the last date when the unit was inspected and found not to have bed bugs. So landlords, if you don't meet your end of the bargain when we're dealing with bed bugs, you're going to be responsible for a tenant's actual damages. I don't know what that's going to be. That's going to be a case-by-case analysis. Landlords, if you're a tenant and you're not allowing inspection, you're not allowing entry into the residence, you're not getting your apartment, your residence ready for it to be inspected, your landlord can take you to court and try to have the court order that the landlord be granted access to inspect and treat the dwelling, and may also require the tenant to comply with specific inspection and treatment measures. And that's going to just add up on the cost side, the damages side in that type of lawsuit. So we're still in the warranty of habitability. What are the other conditions? We've gotten past the infestations. You also have to have as a landlord, you have to provide an adequate amount of outside receptacles for garbage. If you're in a 50-unit building, one 20-gallon can outside, not going to cut it. But I assume that there's a dumpster there. So I have yet to run into a situation where I found that there was a lack of receptacles for garbage, but it is in there. There also have to be working floors, stairways, and railings. Locks on exterior doors must be functional, and there must be security devices on any window that open. So if you've got a window that opens and the lock isn't functioning on it, or the lock's busted off, that's a warranty of habitability issue. It's also generally a safety issue. Bring that up. The residents must also be in compliance with all applicable building, housing, and health codes, which materially interfere with your life, health, or safety. There's also specific provisions for mold. Kind of view mold as its own category. It's defined as microscopic organisms or fungi that can grow in damp conditions in the interior of a building. A residence is uninhabitable due to mold when there is mold that is associated with dampness, which the condition, if not remedied, would materially interfere with the health or safety of the tenant, excluding the presence of mold that is minor and found on surfaces that can accumulate moisture as part of their proper functioning or intended use. That last part's key. If you've got mold in your bathroom, might not be an issue. If you've got mold in your bedroom closet, it's going to be a different analysis. Appliances are also subject to the warranty of habitability. So a refrigerator, a range stove, or an oven included within the residence for the use of the tenant pursuant to the lease or any other agreement, those are also included in the warranty of habitability. You have a right essentially to have a functioning kitchen because it's part of what you're renting. It's part of what you're paying for. This appliances section, it only applies to the appliances specifically listed in a written agreement or actually provided by your landlord at the beginning of your tenancy. If there's a dehumidifier that breaks down, I don't know how much that would really qualify for the warranty of habitability. If you make a demand based upon an appliance and your landlord replaces the appliance, there's a presumption that the replacement appliance is not done so in retaliation, so long as it does the same basic function. I guess kind of the extreme example I think of in this scenario is if you've got one of the fancy kitchens or fancy refrigerators, you touch the door and you can see all the inside and it's got smart speakers or something, and that breaks and you just get replaced with a normal refrigerator. It's not retaliatory that you no longer have Bluetooth in your refrigerator because it still serves the functions of a refrigerator. It still keeps your food cold. Now, if your refrigerator, if you have a full-size fridge and it gets replaced with your kind of college refrigerators that you see at Target, they're about yay big, then I think there's a different issue there because we've kind of lost the ability to store the amount of food for a residence. So beyond the conditions that are explicitly listed, that list, there's also kind of a subjective catch-all, which is that if there is a condition that materially interferes with your life, health, or safety, flooding, if there's something unique, I think in some situations, given the weather that we're about to go into as the months get colder, if your heat goes out and we're looking at a weekend where the temperature's not going to be above 0, then that probably transforms a heat issue into a life, health, or safety issue. So again, this is a bit subjective because it's going to be a condition that materially interferes with your life, health, or safety, whatever that may be. It also significantly alters a landlord's response. And we'll talk about the response times here in a second. Now, I've been talking about the conditions. But just because the condition is present, it does not automatically mean that your landlord has breached the warranty of habitability. Because as a tenant, you have to first there has to be the uninhabitable condition, and the landlord has received reasonably complete written or electronic notice and failed to commence remedial action by employing reasonable efforts within the requested times. So it's not just that there's a problem, it's that there's a problem, you provided proper notice, and there's been no response. That's when we get to a breach of the warranty of habitability. So when does a landlord have to start commencing the repairs, to commence remedial action? There are going to be 3 different timelines. It's going to be materially interfere with health or safety, one of the listed conditions, and then there's also mold, which I group on its own because it kind of has multiple benchmarks within the timeline of it. Life, health, or safety, landlords have 24 hours to start fixing the problem. Statutory condition. So my refrigerator doesn't work anymore. My stove's out. The window's broken. So in that situation, landlords have 96 hours, so 4 days to begin fixing the problem. However, as a tenant, you have to give them permission to enter your residence to start the repairs. If you don't include that permission, then the 96 hours does not apply. It just becomes reasonable. But mold's a little bit more detailed here. So within 96 hours of receiving the notice, landlords are required to install a containment stopping active sources of water to the mold. They have to install a high efficiency particulate air filtration device to reduce exposure, to reduce a tenant's exposure to the mold. They have to maintain that containment unit around that source of water until the repairs are completed. And then within a reasonable amount of time following those first actions, landlords are required to establish appropriate protections for the workers and occupants, eliminate or limit moisture sources and dry all the materials, decontaminate or remove damaged materials as appropriate, evaluate whether the premises have been fixed, whether the mold's been removed, and to reassemble the premises to control sources of moisture and nutrients to prevent it from reoccurring in the future. So you've provided an electronic notice, a written notice to your landlord. Do you have a right to receive some kind of response in return? Yes, absolutely. Landlords, you have to provide a response within 24 hours of receiving the notice. The response does not just say, got your notice, gonna deal with it. It has to include your intention to fix the problem, when you're gonna start fixing the problem, and how long it's gonna take to fix the problem. So you have to, as a tenant, you should be looking for that notice on, this is how they're gonna fix it, this is when they're gonna start, this is how long it's gonna take. You should be looking for that within the first day after you send that notice. Well, what about if your place is in such a condition that you really can't live there anymore? Do you have the right to request, does your landlord have to give you someplace else to stay? In some cases, yes. So if we're talking about a health, life, or safety issue, and you make a request for an alternative residence, then your landlord is required to provide you with either a comparable dwelling unit or a hotel room of their choosing at no cost to you. Landlords, now let's say it's a hotel room and you've got to kind of load some things up and move it on over there. Landlords are not responsible for any of those costs during that relocation period. As a tenant, you are still responsible to pay your rent, as your lease says. And again, this alternative residence, it only applies to warranty of habitability demands that are claiming there's a condition which materially interferes with my life, health, and safety as a tenant. So as a tenant, what are your options if your landlord has breached the warranty of habitability? You've got that uninhabitable condition. You provided notice to your landlord and your landlord has not done their part. They've not met their end of the bargain here. So as a tenant, you can end the lease. You can terminate the lease and move out. You can go to court and try to obtain injunctive relief. You can defend against an eviction for non-payment of rent if you withhold rent. You can also there are other monetary options. One of those is to deduct the cost of repairs from your rent. I'd advise against that, and we'll touch on that in a little bit. So withholding rent, your landlord hasn't taken action. You do have the opportunity to withhold your rent, but if your landlord then files an eviction for the non-payment of rent, you're either going to have to pay that amount withheld into the court as a bond, or you're going to have a hearing on whether or not you are indigent for the purposes of the warranty of habitability, which would waive the requirements of a bond. I'd recommend seeking legal advice before you take this step of withholding rent, because you could be setting yourself up for unnecessary late fees. Let's say you didn't get the notice right. You're kind of taking an unnecessary risk. Also, as a tenant, you have the right to file a lawsuit for the breach of the warranty of habitability. And one of the things you can seek as kind of your damages in a case is that you've been paying full value rent for a residence that is no longer worth that full value. So you can seek that, how much lower your rent would be if we take into consideration the uninhabitability. If your place is in such a bad condition that it would not be worth anything, then or a landlord wouldn't be able to rent it because it's so uninhabitable, then a court could find that the fair market rental value is $0 and award all the rent that you've been paying during that time, since there's been a breach of the warranty of habitability. Also in that situation, it doesn't become a case where you're kind of risking your tenants, that you're either going for an eviction or the warranty of habitability. You don't have to make that choice between the two. You can also deduct the cost of repairs. This is a very specific process. It does not apply to every tenant in every residence situation. You cannot deduct for certain issues. I would seek legal advice before considering this, because there are also a lot of ways that this can go wrong, as far as getting estimates, who you can get an estimate from for the repair work. And if you wrongfully deduct rent, then a landlord can file an eviction and seek a money judgment in the amount withheld. And you may be setting yourself up for an eviction for non-payment of rent. And if you do it in bad faith, you know that there's no good cause to deduct those costs, or you didn't get the repairs completed and you deduct them, then your landlord can seek an automatic eviction judgment and 2 times the amount that was withheld. So this is a very fact-specific option, and I would not recommend taking this option without first getting a second opinion on it. Because if you do it wrong, it can go very wrong. Are there any exceptions to the warranty of habitability? I mentioned earlier when we were talking about reviewing the lease that yes, there are limited exceptions. So yeah, but that exception is going to be in a separate writing. So it has to be separate from the lease agreement. It has to be a separate agreement that you make with your landlord. It has to be signed by you and your landlord, and it has to be supported by consideration, meaning that maybe that it says your rent's going to be reduced from this amount to this amount, because the reason for that as a tenant, there has to be consideration is that you have these skills, these special skills to be able to perform this work. You've done HVAC work your whole life. You're a journeyman carpenter. You're an electrician by trade. So you have the ability to take on this repair work around the residence, but it has to be supported by consideration. And if you have the skills to perform the work, then let's say you're an electrician. If there's an electrical issue, you then take on the burden to do the repair work yourself. You also then cannot claim that there's a breach of the warranty of habitability for bad electrical work, because you've taken on that responsibility. And you've taken that, your landlord has given you that responsibility and you've taken it on. And your landlord has paid you to take that on, because that's what that consideration part means when we're talking about the separate writing. So in addition to the warranty of habitability being a defense against an eviction, it's also a defense in a collections action for unpaid rent. So again, I briefly touched on this. If you're alleging the warranty of habitability as a defense in an eviction case, you'll have to post a bond unless you're found to be indigent pursuant to Colorado law. If you're found to be indigent, then you won't have to pay the bond and you can still use that defense. Checking my watch to make sure we're saving enough time for questions here, folks. So here is what a court's going to look at to determine whether or not you meet the definition for indigency for the warranty of habitability purposes. I'm just going to kind of move past the slide. Slides will be made available. That's just what the judge is going to be looking at if you find yourself in this in a hearing on this matter. All right, so these are other updates to the warranty of habitability that have been somewhat recent. As I mentioned a few minutes ago, one of the things you can seek is that deduction in the fair market rental value. So a court has to determine that amount, what the reduction is of the rental value in its uninhabitable state to the date of the trial. A court shall, if the court finds the landlord has breached the warranty of habitability, they shall deny possession to the landlord and deem the tenant the prevailing party, which is significant because if there's an attorney fee provision and you're represented by counsel and you're the prevailing party, you can then seek an attorney fee judgment. Now, the reason the court has to determine what that amount of rent is, that reduced amount, is because as a tenant, you're going to have to pay that rent that has accrued up to from when you started withholding up to the date of trial. And you've got to pay that to either the court or the landlord within 14 days of the court's judgment. But if you don't pay within those 14 days, then the court reverses itself and deems the landlord and will evict you as a tenant and deem your landlord and award a judgment for possession in your landlord's favor if you don't pay that reduced rent within the 14 days after the trial. The court also may order that the landlord make repairs and correct any uninhabitable conditions. And may also order that the rent remain at that reduced level until the residence is brought back to an inhabitable state. And the court keeps jurisdiction over the case to ensure that those repairs are made in that situation. Other potential resources, if you're dealing with a conditions issue, are going to include the Planning and Community Development Office, the Department of Health, if you're outside of city limits, the County Planning and Community Development Office. Just a brief bit here on code enforcement. Code enforcement is not the warranty of habitability, and they will tell you that. They only have the authority to enforce the minimum housing standards of the city code. They do not have the authority to enforce the warranty of habitability. That's for court. Warranty of habitability is going to happen in court, not with code. And some issues, they don't all overlap. For example, mold is not included in the city code. It's included in the warranty of habitability, not city code. And if I am recalling correctly, I believe window screens are included in the city code, but they're not included in the warranty of habitability. So it's not kind of a one-to-one direct correlation here or overlap. You can call both. There's nothing saying that there's nothing preventing you from calling code enforcement and providing your landlord with a warranty of habitability demand. And your landlord cannot retaliate against you for doing either of those things either. So moving into security deposits. So when can your landlord keep your deposit? There are only a certain number of reasons that this can occur. Damage beyond normal wear and tear, non-payment of rent, those are going to be the two big ones. If you abandon the residence, yep. Also, if before you move out, if you hire repair crews, if you hire cleaning crews, and you kind of say, put it on my tab, for lack of a better term, then that's also can be withheld, as well as any unpaid utilities. So what's normal wear and tear? This is the usual deterioration which occurs when you're living in a residence. What do I mean by that? It's that your most common path along the carpet is going to have more wear than the rest of the carpet. You're going to kind of have that footpath from all the traffic in the same spots. There's likely to be smudges on walls. That's normal. What is not normal? Wear and tear. Careless or intentional destruction of property. You punch a hole in the wall, that's not normal. Don't do that. That's going to be withheld. So what should you do when you move out of your residence? Clean it, try to get all the smudges off. One key thing is, and this is why I mentioned kind of the range and the stove at the beginning, put in the time to clean the stove because somebody's going to have to, and it's going to be a lot cheaper in the long run if you do it yourself. All right. Do another walkthrough if you're able to, and do that walkthrough with that sheet that you filled out when you first moved in. Take another set of pictures, provide them with a set of pictures, and try, if you can, try to take photos from the same angle of when you moved in, showing this is the same condition. I know it's in some cases that's not going to be possible, but do your best to do that. That way you can create the beginning and the end and document it to the best of your ability. Got to return the keys. If you don't return the keys, you hold on to them, your landlord's not going to know what to think. So they're going to think you never moved out because, well, they never gave me the keys back. Also, you're going to want to provide a forwarding address. Your landlord is only required by law to send your security deposit or the accounting statement to the last known address. Well, if we think about that, the last known address to your landlord is probably going to be the home you're moving out of right now. So if you don't send that, if you don't provide that forwarding address, then chances are you're not going to get your deposit back because your former landlord only has to send it to the last known address. Keep copies of how you provide that. Again, I would do it in writing. Don't just say it verbally, because there could be, maybe it gets misheard. And you don't want to be in a situation where you're trying to prove what was said when you can show what was written. How long to return your deposit or an accounting statement? By law, it's 30 days. If you have a written lease agreement, it is likely going to be written into the lease agreement that is up to 60 days. But 60 days is the maximum amount of time by law in a written lease that your landlord can have to return either your deposit or an accounting statement listing the reasons that you are not receiving your full deposit. So on a verbal lease and an oral lease, only 30 days. So what happens if your landlord does not return your deposit or does not return your full deposit? As a tenant or a former tenant, you've got to send a demand letter. I say certified mail, really just go with the track. If you're sending it to a PO box and you send it certified, you're going to wait a few weeks and then it's going to get returned to you because nobody's signing for things at a PO box. But send it with some kind of way to show that, hey, it was received. Keep a copy of the letter as well. These are just some sample templates. There's really not any kind of magic words to use in these, but you want to indicate that generally I was a tenant at this address, these dates, I paid this, I paid whatever amount in security deposit. It's been this much time since I moved out, and I disagree with your withholdings, or I haven't gotten anything. Landlord may only return part of your deposit. Maybe you get half of it back and the other half's kept for carpet cleaning, patch some holes in the wall. Maybe you've got a little toddler that decided to test out their artistic abilities on the lower section of the wall. You may just find yourself in that situation. Beware of any kind of restrictive endorsement. If you get a letter that says, signing of this is a full and final resolution of the dispute, resolves any and all claims, you may be waiving any kind of right to dispute the withholding. So just be careful about any kind of language that may strike you as a bit different in any kind of accounting statement. If you don't, so you send the 7-day letter, let's say you don't get a response, or you get a response that you're not satisfied with because you still dispute why it's being withheld. As a tenant, you can file a lawsuit. I say small claims action because for the most part, security deposits are going to be less than $2,500. I say $2,500 because in a small claims action, you can seek up to $7,500. And if your former landlord has wrongfully and willfully withheld your security deposit, you can seek 3 times the amount of the wrongfully withheld security deposit. So You can seek a maximum of $7,500 in small claims court, $25,000 in county court if you think that you have a security deposit that may be greater than $7,500. Willful withholding, Colorado case law says that after the 7-day demand letter you send, withholding after that time is willful. So early lease termination, moving on from, we've kind of gone past the security deposit, but let's say something happens and you really need to be able to terminate your lease early. Can you do that? Maybe is the answer. The terms of your lease may provide you with how that can be done. Oftentimes, there's going to be some kind of cost associated with terminating your lease early. But again, this is why it's so important to be reviewing every letter, space, punctuation of your lease itself. Breach of the warranty of habitability, you can terminate your lease based upon that. And that's if you can terminate your lease after 10 days, but less than 30 days after the breach has occurred. If you are the victim of domestic violence, abuse, stalking, and or unlawful sexual behavior, there are protections for that victim to be able to terminate the lease without any kind of penalty, military orders, act of God, fire, flood, earthquake. But so long as that act of God wasn't caused by your own negligence. If you put something in the stove and you go and take a bath, fall asleep in the tub, your house burns down, nope. If you leave your water running and go to the grocery store and flood out your neighbor's apartment, no, that's not going to be a way for you to be able to terminate your lease early. Even if you have to move out, you may still be responsible for the money parts on your lease. Also, if there are multiple breaches of the warranty of habitability, then, so within a 6-month period, if the same condition renders your home uninhabitable twice, you can terminate your lease and you don't have to give your landlord any chance to fix the problem. You do have to provide a 14-day notice to your landlord saying, there's been a second, my home is uninhabitable for this reason. This is the second time within 6 months. I am terminating my lease and moving in 14 days. This does not apply to appliances. So if you have a fridge that goes out every 3 months, sorry, you have a fridge that goes out every 3 months. It might be an electrical issue, but if it's just the fridge, that's not going to be grounds to terminate the lease early. All right, so moving into the Mobile Home Park Act, these are additional rights for tenants in mobile home parks who own their homes, and it also applies to residents as well. You have a right to a written lease or rental agreement. The termination of tenancy must be for cause. It can't just be served by a notice to quit. You have it as a homeowner in a park, you have a right to a 90-day period to fix any problems or any claimed violations of rules. It's still 10 days for non-payment, but it's 90 days for everything else. A notice to quit provides 90 days to either move or sell the home. A security deposit cannot be greater than 1 month's rent in a park. The lease park management has to adequately disclose the terms and conditions of the tenancy in writing in a rental agreement. So when is the rent? What are those disclosures? The day that unpaid rent is considered in default for late fee purposes, the name and mailing address where a manager's decision can be appealed, and all charges to the homeowner other than rent, including late fees. So if there are any kind of water connectivity fees that are anticipated, they have to be disclosed in the lease agreement in a park. So what constitutes cause for termination? We have a list here. Homes not in compliance with local ordinances and state laws, not following written rules and regulations, the park's condemned or it changes use, knowing false or misleading statements on an application, and then either your conduct, a guest's conduct, or a friend's conduct unreasonably endangers the life of a person in the park, damages or destroys the property of a person in the park in a willful, wanton, or malicious manner, or constitutes a felony offense, or was the basis for an action that declared the home a Class 1 public nuisance. Class 1 public nuisance does not mean that you're bothering me. It means that you have been taken to court and your home has been found to be a public nuisance. That is a legal standard. Public nuisance includes things like betting parlors, brothels, paraphernalia shops. There's a lot of different things that can render a residence a public nuisance. So when can the park change its rules and regulations? If they don't have with your permission, the rule changes immediately and goes into effect immediately. Without your permission, it goes into effect in 60 days. As a homeowner in a park, you have a right to privacy. They have no right, park management has no right to enter your home without first obtaining your written consent to carry out statutory duties in the case of an emergency or when the home's been abandoned. If you provide written consent, you can take that back, revoke it at any time. If your landlord does have to enter the home, they have to provide you with a written notice 48 hours in advance with an approximate time of entry and the approximate date. The approximate time of entry and the planned date of entry, and it has to be delivered to you as the homeowner in a way that you're reasonably likely to see it. They can't kind of slide it under a welcome mat and hope that you see the tip of it sticking out or something like that. There's also another program put in place for homeowners in a park is the Park Dispute Resolution Act. And this is a mediation process that is unique for mobile home parks. I'm going to kind of speed through this section so we can get to questions here just a little bit and also touch on some updates. There is a process for resolving disputes in mobile home park. This was kind of born out of the recognition that there's a unique relationship between park management and homeowners in that the homeowner owns the home, but the park owns the land. So there's a lot of information here about the dispute resolution process. I apologize for going a little, but I did want to get to the updates here. And these are limited to the Mobile Home Park Act. There were some significant updates that went into effect on October 1st of this year. They have been the big changes this fall regarding tenants' rights. So landlords are not able to make any oral or written statement threatening an eviction for reasons that are not grounds for an eviction. If a park management or a landlord violates this provision, it can be liable to a homeowner for up to $20,000, in addition to any other remedies authorized by law. There's a lot of new rules regarding changes of use in park, or just in kind of the park's obligation to provide offers for purchasing homes from homeowners or for providing relocation costs for up to 100 miles for homeowners. Landlords are not able to increase rent in a park if the park does not have a current active registration filed with the Division of Housing, has any unpaid penalties owed to the Division of Housing, and those unpaid penalties can come from the dispute resolution process that I skipped over this evening. If the park has not complied with any final agency order issued by the Division of Housing, can't increase the rent. Any increases issued in violation of the law have no force. They are not valid, and the rent has not increased. Park management can't charge homeowners or residents a fee to use any common space. They can charge for cleaning or damage costs following a meeting. Landlords are required to host and attend a meeting for residents of the park if requested by a homeowner or a resident. There are kind of limits on, I think it's 2 meetings per year that can be requested. This is a relatively new law. I haven't yet really dug deep into it as far as what the ramifications would be on that specific point about not agreeing to meet. Then there are more protections. Park management cannot retaliate against any homeowners for organizing activities or voting on matters in a homeowner association. Can't force a person or require a person to sign an agreement. Park management are not allowed to require a homeowner to sign a new lease or agreement in violation of the Mobile Home Park Act. And they also can't mislead a homeowner about their obligation to sign a new lease agreement. This is the rule that I really wanted to get to. And that's that one of the biggest changes, in my opinion, is that accessory buildings on lots are now the property of the homeowner. And park managements are not able to impose rules regarding an accessory building unless it's for a specific reason. Any rules regarding a shed or an accessory building are going to be presumed to be unreasonable by law unless they're strictly necessary to protect the health and safety of residents, unless it is strictly necessary to comply with federal, state, or local government law or rule. If it is voluntarily agreed to by the homeowner without coercion, or if it's a park managed by the homeowners, if it's been approved by the bylaws of the organization, and at least 50% of the homeowners are members of the organization. If you have a question on whether, if you're wondering if this situation applies to you, I would strongly encourage you to apply with CLS to help, in hopes of having someone take a look over your case, or to utilize the call a lawyer clinics that other organizations around town offer as well. One kind of weird thing here is that new homeowners may be subject to rules that the prior homeowner was not. Just because because if the prior homeowner did not agree to the rule, then the new homeowner may be subject to it. There are also new restrictions on management's approval of a potential new home buyer, notice requirements for selling a park, for notice requirements for bilingual homeowners and residents for selling a park, expands upon a homeowner's and residents' rights to pursue a civil action against a park, updates the dispute resolution process, and expands upon the rules for record keeping related to parks. So now we're in the eviction stage of things. We're at a spot in our tenancy where there's been a dispute and our landlords are taking us to court to try to evict us. This is required for any eviction in Colorado. Evictions happen in court. If you get a notice to quit, or if you get a demand for compliance, that is not an eviction. Have to go to the court process, cannot resort to self-help. The Forcible Entry and Detainer Act lists the reasons that somebody can be evicted. Got some general forms here. These are state forms, are not required, but you've got, generally speaking, a notice to quit and a demand for compliance. Again, there's no specific language required. It doesn't have to be notarized. It doesn't have to be served by a process server. It doesn't have to be signed by a judge. It doesn't have to even use the state form. So long as all the information fits, it could be on a post-it note. I think that's a bad practice, but it can be. So a notice to quit has to, or a demand has to describe the property. A notice to quit has to describe the date and time of the tenant's termination of tenancy. It has to be signed by the landlord, landlord's agent, or attorney. Oh, and it must be served by statutory deadlines. For example, a month-to-month tenancy is entitled to 21 days of notice prior to the end of the month to terminate the month-to-month tenancy. Not just 21 days, 21 days prior to the end of the applicable tenancy period. So we are now on November 16th. If you are on a month-to-month lease, your landlord cannot terminate your tenancy before the end of November. There is not enough time left in this month. So now the next step after receiving the notice to quit or the demand for compliance is being served with a summons and complaint. We've got just kind of blank ones up there. The summons, there is language required in the summons. This is the document that tells you this is your court date, this is when you need to appear. It must obtain a list of available resources with a website link, a copy of a blank answer form, and a form that allows either party to request all relevant documentation in possession of the other party. There's the statute for what a summons is. Service. There are two ways that a demand or notice can be served. Personal service, it's where you're physically handed the document, or service by posting. If it is service by posting, landlords must first try to serve you personally. They can't just walk up and tape it to the door and walk away. You have to make an attempt at personal service before you can serve by posting. If we're talking about taking it one step further, if it's service by posting of the summons and complaint, then let's say it's a case for non-payment of rent and it's serviced by posting. If there is no answer filed and a default judgment enters, then there can be no money judgment entry as well. If this is getting a little bit too detailed, I can appreciate that. Please reach out and seek a second opinion or some guidance if you find yourself in that position. Now, when you get the summons, you've got a few options. You've got 3 options for when you receive a summons. You can do nothing. You're going to get evicted by a default judgment. You can reach a settlement agreement with your landlord, or you can file an answer. An answer is stating the legal defenses in response to your complaint. FED cases are at its base, they're contract law cases. So there are incredibly heartbreaking stories that judges are going to feel incredibly sympathetic to and empathetic towards and still evict you because it's what the law says, it's what the contract says. So saying, I need more time, I've had a medical trauma, those are not likely to be legal defenses. So your answer is due by 5 p.m. on the day of the return. Even if your return date says 8:30 or 9:30, your answer is due by 5 p.m. The defense of an improper notice, it can be raised in either the answer or by filing a motion before the hearing. You cannot raise the defense of improper notice for the first time at the hearing if it was not previously raised. So you can't, that's the purpose of the answer, is to say these are my legal defenses. An improper notice would be a legal defense, so you've got to include that in the answer itself. The trial by law is supposed to be scheduled within 7 to 10 days from the date that the answer is filed. Not the return date, the date that the answer is filed. If you file your answer before the return date, that's when that time starts running from. Between the filing of the answer and the trial date itself, in that 7 to 10 day period, the court shall order that the landlord or tenant provide any documentation relevant to the current action. Sorry. Now, in non-payment cases, this has been a substantial change in the law over the last year. This went into effect fall of last year. I can't recall off the top of my head if it was October 1st or November 1st. But if the basis for the eviction is the non-payment of rent, even though that 10-day period has expired on the demand, tenants still have the ability and the right to cure the non-payment by paying the amount that is now due. Not just necessarily the amount on the demand, because there may be a new month that's due. So if you received a demand in early October and you're going to court in mid-November, don't forget to factor in the November rent as well. But you have until a judge enters a judgment for possession to be able to cure the non-payment, bring your balance to 0. If that does occur, then your landlord, the court is required to dismiss the case with prejudice. So, and that can be paid to either the landlord, or if your landlord refuses to accept the payment from you, you can go down to court and deposit those funds into the court registry. Once the court confirms that the full amount's been paid, they're going to dismiss the case with prejudice. The warranty of habitability is a defense in eviction cases. And it's beyond just the non-payment. If your landlord retaliates against you for making a good faith complaint to the landlord or a government agency, think code enforcement, regarding warranty of habitability or organizing or becoming a member of a tenants association or similar organization, they cannot serve you with a notice to quit based on that. So a tenant can assert the breach of the warranty of habitability as a defense to a non-monetary violation, rule violation, notice to quit, etc. Essentially what you're stating in that situation is that this is a pretext. This is all just kind of a disguise because I actually made a complaint about the warranty of habitability. You have to have something more than just timing. Timing alone is not going, it's not going to be presumed that, well, the timing doesn't look right. There has to be more evidence to show that this notice to quit, that this eviction was brought for retaliatory reasons. Make sure to appear at your return date. And I put appear in quotation marks because, well, at least here in El Paso County, return dates are virtual. So depending on where we're at in the state, it may be a different practice. So make sure that you're checking with the court to see what that process is. Now, once the trial itself occurs, if the court ultimately rules in favor of your landlord, they're going to issue what's called a judgment for possession. Judgment for possession is the legal phrasing for an eviction. The court's not going to say I'm entering an eviction. You're going to say, I'm entering judgment for possession. Now, after that judgment gets entered, 2 days later, the court will then issue what's called the writ of restitution. That's the document that allows the sheriff, that allows law enforcement to come into the residence, remove your property, and return possession back to your landlord. That writ of restitution cannot be used until 10 days after the judgment for possession. So I've been stated multiple times, have to use the court process, cannot use self-help. What happens if we have, if you feel that you've been wrongfully evicted, that you've been evicted without court process, you can file a civil action. You can sue your former landlord. You can recover damages, costs, reasonable attorney fees. If the court finds that there has been an unlawful removal, then it's either going to be 3 times the monthly rent or $5,000, whichever is higher. The court may also order that possession be restored. So you could seek 3 times your rent or $5,000 and an order restoring possession so you can get back into the residence you were wrongfully evicted from. Fair housing, this is the prohibition against discrimination. There's both federal and state fair housing. It is prohibited to discriminate against a tenant based on their race, color, disability, sex, sexual orientation, including transgender status, national origin, ancestry, religion, creed, marital status, and/or familial status. New legislation is pending to add gender identity and gender expression as protected classes as well. There are exceptions to fair housing. Those occur where we have an owner-occupied building with 4 units or less, single-family housing sold or rented without the use of a broker, or housing operated by an organization, private clubs that limit occupancy to members. Very briefly, service animal versus emotional support animal. Service animals are protected explicitly by the Americans with Disabilities Act, not a pet. And more specifically, it's either a dog or it's a miniature horse. Only a dog or a miniature horse can be a service animal. Your cat cannot be a service animal. Nothing else can be a service animal. It has to have special training to perform specific tasks. Emotional support animals are not covered by the Americans with Disabilities Act. However, they are potentially protected by the Fair Housing Act because you have an emotional support animal that is in some way, shape, or form tied to a disability or a medical condition. So you can submit a reasonable accommodation request to your landlord to accommodate your emotional support animal. What is a reasonable accommodation request? So kind of going back to the Fair Housing Act, it is a discriminatory practice. It is discrimination to refuse to make a reasonable accommodation that is necessary to afford a person with disabilities the equal opportunity to use and enjoy the residence. So if we're dealing with an emotional support animal, we're dealing with a medical device. Mental health is still healthcare, but a medical device that is used for emotional support. That's not going to be explicitly protected by the Americans with Disabilities Act, but because this is in some way, shape, or form under the guidance of a medical professional, you can submit a reasonable accommodation for your landlord to accommodate your disability by permitting an emotional support animal that would otherwise not be permitted. There's no magic language that you need to make this request, but you do have to state what it is that you are requesting, what the accommodation is that you are requesting. I've been talking about it in the sense of emotional support animals, but if you have issues with mobility, and let's say there's a parking lot with no assigned spots, you could request an assigned spot in the front row or a grab bar installed in your shower, something to that effect. It does have to be in writing, and it must, again, it has to state what it is that you are seeking, what the accommodation is specifically that you are seeking. There is a sample letter that are in the materials online on the city's website, but here's one right here, just kind of a form. Just says, I am requesting to your landlord, accommodate my disability by providing, and then that's where you want to include, this is my request. This is what I need to accommodate my disability so that I may have the same use and enjoyment of my residence as all of my neighbors do in this community. So with that, I will open it up to questions.
And Clinton, the library does close at 8, so
At
we need
8,
to
so
wrap
we've
up
got-
a couple minutes
We've
before.
only got a couple minutes, so I'm going to go to the chat here. Thank you, folks, for bearing with me. I know I was particularly long-winded tonight.
We have a microphone here for anyone who has questions, so then the folks online can hear the question as well.
All right, I am going to start in the chat here. And hopefully I can scroll up.
Okay, you're at the top of the chat.
All right. Is the late fee notification valid if it is included in the demand letter, or does it need to be a secondary notification? I think that it's possible for the demand letter to be valid as the secondary notice for the late fee, but it's going to depend case by case. Is there a limit on how much a landlord can raise the rent within the 12 months? There is not a limit on the amount that rent can be raised, only that it can be raised just one time within for each 12 months of occupancy. When is the tenant responsible for mold or bed bugs, or if everything is working and the tenant causes the water, mold, or bed bugs, etc.? In regards to the bed bugs, that only becomes the tenant's responsibility when they've knowingly and unreasonably failed to comply with the requirements for inspection or treatment. One of the kind of broader issues with bed bugs is you can't pinpoint, for the most part, you can't pinpoint the source. As for mold, it's a bit of a broad question, so I'm not really sure when a tenant's responsible for mold. Just try to be mindful of your maintenance of the apartment. I think more of bathrooms in this sense. Don't allow, try to air out the bathrooms, don't allow moisture to accumulate in that setting. Is it legal for a landlord to charge maintenance fees to fix items on the warranty of habitability list? I don't know. It would depend on the fees. And if this is in response to a work order, or if this is in response to a allegation of uninhabitability. Does a landlord have to accept Section 8? Yes. If they don't, is that considered discrimination based on source of income? Yes. That does not mean that has occurred in your situation, but generally speaking, landlords are not able to refuse to accept a voucher. Does a landlord of a single family home have to provide a garbage can, or does that just apply to apartments? It's going to depend on the language of your lease. For the most parts, they're going to be responsible for supplying that trash service to the property. So unless there's something weird in your lease, your landlord is going to be responsible for trash. How much notification should a renter be given before an increase? Assuming that's for an increase of rent, that is 60 days written notice. Management hired sidewalk redone. However, the concrete staff left a little ditch beside the sidewalk the entire length of the sidewalk. This causes sidewalk to be a possible cause of falling. How to get manager to get sidewalk finished? That's going to be a little too fact specific for me to get into this evening. If you do have a concern over those type of structural issues, you may want to contact, say, code enforcement, or just to ask them questions about whether that would be permissible, or county and regional building. But it's just based on that alone, I don't know how or if it would be possible to get the management to get sidewalk finished. What happens when you get a eviction notice from lawyers, then pay that part of the rent that is late, but still late on the new month? It's going to depend on the demand itself, how the demand is written and structured, and what part of the case we are in. If you do find yourself in that situation, I would strongly encourage you to call into the Ask a Lawyer clinic, or to apply for potential CLS services. What to do when unlawful security is kept without receipts? If we're talking about a security deposit, you have to send a demand letter to your former landlord. That's the first step in the process. What is the statute of limitations for filing a civil suit against a former landlord? It's going to depend on the nature of the civil suit. For a security deposit matter seeking 3 times the amount wrongfully withheld, that has to be initiated within 1 year. For a lot of other contract disputes, we are generally looking at a 2-year statute of limitations, generally speaking. But again, I am not providing legal advice, information. If you have that question, do not assume that it is just 2 years. Go make sure, because if you wait until the 23rd month, you're also probably waiting too long anyway to get a case properly investigated and filed. So address that problem soon, address that question sooner rather than later.
That's the last one.
All right, that is the last from the chat. Sorry, I'm just trying to not stand.
Blind yourself.
I'm trying to retain some semblance of vision. But folks, what questions, any questions from the room here?
Yeah, I had one.
Sure.
On,
Wait, hold on, we're gonna bring the microphone, that way the folks online can hear you.
on the warranty of habitability.
Yes, sir.
Does it really have to like threaten my life, or is it just like
It doesn't have
you
to
can,
be.
the front door closed, you can see daylight across the top and then across the, down the side, and if you really hit it hard enough, it'll just open.
Well, so it's not threaten your life, it's materially interfere.
Okay,
So there's a big difference there. All right.
well, it does cause the heater to come on a lot. I mean,
But remember, if waterproofing and weather protection of your roof, walls, doors,
okay,
and windows. So beyond just kind of maybe taking it one step lower, even if this isn't a material interference with your life, health, or safety, if you don't have sufficient weatherproofing on your doors, that's not in compliance with the warranty of habitability. Of course.
Okay, does I have a question about the month-to-month agreement or lease or?
Yes,
Okay, so you said like if you have a verbal lease, then it's presumably month-to-month.
yes.
Okay, now, are you saying that the month-to-month agreement is being signed every month? It's actually being signed and copied every month, or is it just a month-to-month agreement and that stipulation of being signed or in agreement each month is in the first agreement, or in the first lease? Maybe I'm not answering, I'm asking it right.
Let me see, let me take my best guess at the question and let me see if I answer it accidentally.
Okay.
So with with an oral lease agreement, the reason that I say that it's presumed to be month to month is that one of the things that a court will look at in an oral lease agreement, if there's a dispute, is how frequently is rent paid? And oftentimes rent is paid on a monthly basis. So that's going to be a good indicator to the court that this is a month-to-month agreement.
Correct.
All right, because we're trying to create a term when there's nothing signed. Now, if we're going to, typically, this could occur, you could sign a new lease agreement every month for a month-to-month agreement, but more often than not, what happens is one of the clauses in the contract itself says something to the effect of this lease automatically renews
Right, okay.
each month unless either party provides proper notice. So whether or not you have to sign, do you have to sign one every month? You're not required to. Is it possible? It is possible, but more than likely, just for kind of simplicity, just for not having to go through executing a new lease every month, the initial lease agreement oftentimes has language in it indicating this is going to automatically renew. It's automatically going to roll over for identical terms. And you can see that on a year-long lease agreement as well, where it'll say this agreement will automatically roll over on identical terms unless either party provides notice, whatever the language may be. So it's going to depend on the length of the lease. I say the oral leases, I say presumed to be month to month, because one of the key facts the court looks at is how often is rent paid.
Okay.
And since the most common form is we pay our rent every month, that's kind of that's generally how they'll interpret that oral lease as month to month. On a written lease, could sign one every month. That seems like a lot of wasted time, energy, and paper for both the landlord and the tenant. So oftentimes it's just going to be included in the lease that this is going to automatically renew. All right.
Thank you.
Well, of course.
Any other questions?
Sorry, I had one more. You were talking about normal wear and tear.
Yes.
Now, if you've occupied the residence longer than the warranty that's on the carpet, would you really be responsible for actually just the wear and tear? I don't mean tearing it up or stains. just
Sure.
Is there any way they can say, you know,
It's
especially
possible.
since the
I've,
carpet needed to be
so-
replaced when I moved in?
So the question is, let's say you've been living in a place and you've been there longer than the warranty on the carpet. I've seen judges tell, they haven't been my cases, but the answer is it's going to depend. Now, really though, we're getting to the value of the damages. So if you have a carpet that's been there since, I don't know, let's say 1987, chances are it's not going to be worth much.
Right.
So it's going to be hard for a court to impose damages on you if the carpeting itself is worth $0. And I've had judges indicate that. I've just kind of talked about that before, of that there's no kind of table in the law of this is how much things are worth after a certain period of time. But at a certain point, just logically speaking, there's not going to be any value to the property that's that old. So barring lighting the floor on fire, it probably isn't going to matter if it's stained. And also, don't light the floor on fire.
No.
Just to be very clear, bad idea.
Burning carpet stinks.
All right, we are about out of time this evening. We are going to get the boot. Thank you all again so much for taking the time out of your week to come and listen. Folks, thank you so much online for tuning in this evening. Do we have any last questions before we conclude this session tonight? Yes.
On a lease, like for as a landlord, on the late fees,
Mhm.
if I have a lease that's like from 2 years ago, do I need to update that? Like, can I do an addendum to change that?
You can.
Or do I need to do one, or do I just need to do a new lease?
Well, you can certainly try to do an addendum. You can't force anybody to sign it.
Well, it's gonna benefit them anyway.
It may. I'm just saying, you can't force a signature on the addendum because the contract's already in place.
Is that legal though? An addendum, is that legal?
It's legal, but you can't force the signature on it. An addendum is very much legal. It's just a modification to the contract,
Right,
but you can't force the signature on it.
right.
All right. Now, if it's an older lease clause, the remedy really would be if the late fees are out of sync with the law, it's just not going to be enforceable.
Okay.
So if you try to charge a late fee that's violated with the law, the court's not going to enforce it and you're going to get dinged with a penalty. All right. So yes, you can do an addendum. Tenant does not have to sign it though.
Okay.
All right.
We're gonna close the entire library by 8, you guys shut it down by 15 minutes.
Thank you.
All right. Thank you so much, folks.
Thank you.